in the matter of People versus Joshua Lanto. Mr. Lanto, can you hear me?
I can hear you.
Okay, counsel, you want to put your appearance on record?
Looks like Mr. Cooch left the room, Judge.
Is he anywhere to be seen?
Wow, right from the start, this hearing feels off balance. The defense attorney isn't even properly present, and the judge is already trying to figure out what's going on. This kind of shaky opening often sets the stage for courtroom chaos, and today, it delivers.
Yeah, he came out and went back in.
Okay. Mr. Greco, it's been indicated to me that somebody wants a 30-day adjournment on Mr. Lanto's case for discovery. Is that right?
That's fine with me, Judge, if that's what the request is.
Well, quick objection. The request was, why don't we just drop this right now?
Okay, Mr. Lanto, you understand that you're the one requesting that you be given 30 days to get discovery. It's not the prosecutor.
Well, the first thing I want.
Here, the defendant pushes for something we hear a lot from so-called sovereign citizen defendants, demanding jurisdictional proof. To him, it sounds like a simple request. But to the court, it's a red flag. Judges usually view this as pseudo-legal nonsense, and they don't have patience for it.
Okay,
You want a trial today? You want a trial today?
Well, I mean, I'd even be willing to, sign a guilty plea today if the court can just produce the factual evidence of jurisdiction. It should be in my file somewhere. I was asking for the same thing up in the Clarkston courthouse, and they send me to the Oakland County Jail.
Mr. Lanto, I'm not going to produce anything. I don't have to. I'm the judge. And as far as I know, the prosecutor can only produce what he wants to produce.
This is where things snap. The judge bluntly tells the defendant, "You're talking crazy." That's not language you often hear from the bench. Judges normally stay formal and calm, but here, the frustration just spills out. And honestly, you can feel why. The defendant keeps circling back to arguments the court sees as irrelevant.
So we're not doing that. Your attorney's asked for 30 days. Do you want the 30 days or do you want to go to trial today?
Well, let's see what the discovery evidence has to say. But first, if they could, very first thing out of there, they could send the factual evidence of jurisdiction. That would be great. It should be a one-page document. If the prosecutor filed it, fantastic.
Mr. Lanto, you're talking crazy. I would suggest that you listen to your attorney, okay? I'm going to adjourn this matter on his motion for 30 days.
Did you just say, can you
I'm going to send this to the assignment clerk. Mr. Lanto, you're not listening. See, that's why you get in trouble, because you...
Notice how the judge shifts from legal to personal. That's why you get in trouble. You don't listen. At this point, it's less about the law and more about behavior. The courtroom dynamic has turned into a parent scolding a stubborn child.
You like to talk and you think you know it all and you don't listen. I'm going to adjourn your case for 30 days. I'm going to send the matter down to the assignment clerk. She'll send out a notice. Hopefully your attorney will have the discovery that he wants by then and we can handle your case. Okay?
Well, have you kind of calmed down a little bit?
No, you're all set.
It seems like you were getting angry. It seems like you were getting angry.
No, Mr. Lanto, you can leave the meeting. We'll see you.
When the judge tries to adjourn the case, he even asks the defendant if he's calmed down. That's not something you often hear in a courtroom. It shows how much this exchange has gone off track. The judge is treating it more like an emotional intervention than a legal proceeding.
30 days or so. Clerk will send you a notice.
Well, I just want the record to show I've asked these same questions in several courts and nobody has said I'm talking crazy.
Oh, yeah.
That's the first time somebody said I've been anything but reasonable in a courtroom.
Huh, that's amazing.
Huh, right.
You're talking like you're
The defendant insists he's being logical and reasonable, but the judge fires back. You're talking like you know all about the law, and it doesn't make sense to me. This clash shows the core of these sovereign citizen cases. One side believes they've uncovered hidden legal truths, while the other side sees only obstruction.
talking like you know all about the law, and it doesn't make any sense to me.
Well, then let me ask a few questions for clarification.
You don't need to ask any questions. We'll deal with it in 30 days, Mr. Lanto.
Wait, we can't ask simple logical questions today?
Ask your attorney when you see him.
Like I said, I'd be willing to sign the guilty plea and just, be done with this if I just see the factual evidence of jurisdiction, number one. And then
That's
number
what we're
two.
asking for discovery.
Okay, and then the proof of jurisdiction is going to be in there? I'm asking a simple logical.
Here, the defendant doubles down, demanding a yes or no answer about jurisdictional proof. You can hear the frustration in his voice. To him, this is a simple, logical question. To the court, it's just another attempt to derail the process. Both sides are talking, but neither is really listening.
Question. It's either yes or no. The proof is going to be in there or not. It's very simple. It's very logical, actually.
Well, let's see.
Mr. Lanto, I think maybe you ought to come into court in person next time, and your attorney will be here in person, and we can talk about it. So when you get that letter,
Well,
can I put on there that he's in person? I'm going to indicate to the assignment clerk that I want you here in person. You know where the courthouse is?
I feel like
Exactly.
I'd be in danger if I came there. I'd be in danger.
No, you won't be in any.
Now it gets surreal. The judge orders him to appear in person next time, even offering to assign a police officer to watch over him. What was meant as reassurance only terrifies the defendant more.
Danger. I'll assign a policeman to watch over you.
That's the
Chris,
scariest
will
thing I
you
could
watch
ever
over
hear.
him when he comes?
Absolutely.
That is the scariest thing I could ever hear. And that's coming from a very reasonable person.
Okay, we'll see you in person in about 30 days, whatever date the assignment clerk gives you. And you come into court and we'll take care of business, okay?
So what does it mean to take care of business and I got to come in person and you're going to assign a police officer to me? And then you said I'm talking crazy.
No, you got it
Did I
reversed.
just recall what was said on the record? Did I just recall that correctly?
You said no, you said it in reverse. I said first that you talked.
The defendant's response, "That's the scariest thing I could ever hear," is both bizarre and revealing. It highlights just how deep the mistrust runs between him and the legal system. Even an offer of protection sounds like a threat.
Some crazy talk. Then I said, I'm going to adjourn it for 30 days. And then I said, because you're worried about it, that I'd have an officer watch over you while you're in court. We'll see you in 30 days. People versus William Vaughn. Mr. Vaughn here.
Yes, sir. I'm
Mr.
here.
Vaughn, can you hear me?
Oh, then.
Yes, I can hear you.
Okay. Counselor, you want to put your appearance on record?
Thank you, Robert Coots, on behalf of Mr. Vaughn.
Okay. It indicated you want to set this matter over for a jury trial. Is that right?
That is correct, Judge.
Okay.
The hearing ends with confusion, tension, and no real progress. The defendant leaves feeling dismissed and mocked. The judge leaves frustrated with yet another delay. It's a classic example of how sovereign citizen arguments crash headfirst into the legal system, and nobody walks away satisfied.